welcome to everybody, at least in central New York on this cold and rainy Tuesday. We have a great program for you today. I will follow up as I usually do at the beginning on Kathy's announcement and say that we do really appreciate your feedback. And one of the presentations today, which I will be doing at the end, Cont came directly from a number of comments we received about a particular topic that you all felt would be helpful. So thank you again for doing that. It does not fall on deaf ears. All right, let's get right into it. Kathy, if you could switch the slide, please. Okay, so as we do at the beginning of these webinars, we're going to go over what the current numbers are, what we're looking at in terms of COVID. I think you can see here that the spike hopefully has plateaued. We are seeing case numbers start to flatten out in New York. Currently, the daily average as of April 25th was approximately 6,500 cases, which is good news. The spike is obviously not good, but the plateauing, I think, is something that everybody welcomes. It's quite interesting. I went back and looked at the data from about a month ago, and the same information that's provided here on March 28th, the daily average case numbers were 2,900. The daily hospitalized average was 1,022, and the number in ICUs was 154. So we've seen a pretty steep increase in the past month. Hopefully that is plateauing, and we're going to start to make our way back down again. However, I will say, going back to that last slide, you don't need to go back, Kathy, but although the case numbers are still increasing, we haven't seen any policy changes. We haven't seen any updates to mask requirements, no more updates to the quarantine and isolation guidance that was updated multiple times in the first months of the year. So policy is remaining consistent despite the increase in cases. All right, next slide, Kathy. You can see still we have hotspots in central New York. I will point out that Western New York is where the spike is starting to happen. You see in this chart that Erie County has a 127% increase over the past 14 days in their case numbers. Ontario County, a similar very large increase out in Western New York, the Rochester area. So we are seeing cases plateau, I think in central New York, still hotspots, but Western New York seems to be where the trend of increasing cases is happening. So that is what we are looking at in terms of current COVID data. Next up, we have a great presentation. We have two attorneys in two different bond offices who have collaborated together and are going to provide some great information to you all about whistleblower protection. So here to talk about that is Gabe Oberfeld. Gabe is an attorney who's based out of our Manhattan office, and Kat Grezios is an attorney out of our Albany office. So Kat and Gabe, welcome, and please feel free to take it away.
Thanks so much, Adam, and it's a real pleasure to be with all of you today. And as Adam indicated, we're going to be speaking with you about whistleblower protections. Here in this webinar, you've heard content over the last few months concerning changes in New York law that went into effect. What we're focusing on today is the way they interplay with existing Medicaid compliance requirements in ways that perhaps you haven't thought about before, but that we're making sure is on your radar. So with that in mind, Kathy, if you wouldn't mind going to the next slide, please, I'd appreciate it. So what we're going to dig into a bit more deeply in specific is, as I mentioned, the whistleblower standards that have been addressed here previously that became enforceable essentially as amendments to New York law earlier this year in January. And the way that requires us to think a little bit differently concerning the Deficit Reduction Act of 2005, which certainly is familiar to those who are involved as providers of Medicaid-funded services. Many of you on the line certainly have interactions with that funding stream. And so Kat is going to give you a little bit of background on the Deficit Reduction Act, essentially to refresh and orient all of you. And I will talk about the ways in which the whistleblower standard might mean that it's worthwhile to dust off some of your policies and work on some refreshments that we're happy to help you with. So Kat, the floor is yours. Next slide, please.
Yeah, next slide. So as Gabe mentioned, I'm Kat Grazios. I'm an associate in our Albany office. I work primarily in healthcare and also in higher education. And I am here to talk about the Deficit Reduction Act of 2005, also known as the DRA 05 to some, or the DRA 05 to myself. Next slide, please. So you may be wondering why on April 26, 2022, are we talking about the Deficit Reduction Act of 2005? It went into effect January 1st, 2007. Well, the answer is to move forward with our whistleblower policies. It's really important to go back and know the history and the background behind it. So the DRA 05 was a federal law that granted states the ability to modify their Medicaid programs. The general purpose of the Deficit Reduction Act of 2005 and why it was popular in the mid-2000s is because it aimed at securing the future of Medicaid and Medicare. There's a lot of waste and fraud going on that were stripping the program of resources, and so the DRA 05 was developed. The most popular and most infamous provision of the DRA 05 that many are familiar with has to do with the look-back periods for Medicaid planning. That's the 5-year look back that we now have. It was 3 years prior to the DRA 05, but that's the look back period that's used if you're doing any end of life planning or long-term care planning. That might be the provision you're familiar with. But a lot of people on the call here today and a lot of entities on the call should be aware of Section 6032, and that's what employers should be aware of. Next slide, please. So Section 6032 of the Deficit Reduction Act established Sections 1902A68 of the Social Security Act, codified at 42 USC 1396A, which I've provided a small sample of here. This is the relevant language that we need to know about. All this is to say that the DRA 05 created federal requirements in the Social Security law. If you can see the text, it says here, certain entities are going to be bound by these requirements being having a policy in place that covers the False Claims Act, as well as has whistleblower protections in it, which I'm about to go into in a bit more detail. Next slide, please. So you also may be wondering, who does this apply to? And CMS has given the answer that is somewhat, helpful, of entities. And then they went on to explain entities are a number of things, including governmental agencies, organizations, units, corporations, partnerships, or even other business arrangements, including any Medicaid managed care organization, irrespective of the form of business structure and arrangement by which it exists. So all this is to say, really any and all business organizations, business structures are going to be covered by this if, and this is the caveat, you're receiving Medicaid payments of at least $5 million annually. That's the threshold minimum amount to make you qualified for this or eligible to be covered by this. So this brings a number of other questions of how do we determine this $5 million amount? And CMS has clarified that if an entity furnishes items or services at more than a single location or under more than one contractual or other payment arrangement, the provisions of this section are going to apply if the aggregate amount meets the $5 million threshold. So if all of those amounts together get to 5 million, you're going to be subject to this DRA 05 policy. This applies whether the entity submits claims for payments using one provider ID number or a different tax identification number. You're going to be covered. And I cover this on a number of slides that I bring up that there's employees who have to receive this policy, not just employees, but management level employees. And then the interesting bit that's a bit of a caveat is that contractors and agents also have to receive this policy. And we go into this a bit later and how we can assist you in getting this policy to any vendors or contractors that may come into your facilities or work with you. Next slide, please. So essentially what you need to do is establish a written policy that covers these 5 areas. One, it should cover the False Claims Act. That's the Federal False Claims Act, having to do with what I brought up earlier with eliminating Medicaid and Medicare fraud. 2, your policy should cover the administrative remedies for false claims and statements made pursuant to the Program Fraud Civil Remedies Act of 1986. Number 3, Any state laws pertaining to civil or criminal penalties for false claims and statements should be mentioned too. And we'll get into that on the slide. We've provided an example of the New York State Office of Medicaid Inspector General website where our New York State relevant laws are listed. Your policy also must mention whistleblower protections, which Gabe is going to get into further. And additionally, you should mention the roles of the laws in preventing and detecting fraud, waste, and abuse. So more specifically in New York State, we have Social Services Law 363D, which has incorporated by reference the DRA 05. It's really pretty convenient that it combines them into one area, really. Prior to 363D incorporating the DRA 05, providers had to complete an entirely separate DRA 05 certification saying that you were going to have a compliance program that complied with the DRA 05. But since 363D incorporated this, now you get to just complete one form, which there's links to the different forms that you would do provided on this page here, but also now you would do an annual certification that comes up on the anniversary of when your organization first applied to be a Medicaid provider. This was called your certification statement for provider billing of Medicaid. And helpfully, Department of Health will send this to your agency approximately 45 to 60 days prior to your Medicaid anniversary. And that Medicaid anniversary, as I said, is your deadline of when you would submit this. And so in New York State, at least, it is built into some of the processes that you already have. If you have a compliance program of abiding with DRA 05, but we're going to go into further how a lot of times now, especially with different staffing crises going on, it's pretty common for entities to contract or have different vendors coming in to provide services. And so now it's key to get those policies to these individuals as well, who aren't just employees, but agents and or contractors coming in. Next slide, please. And my colleague Gabe is going to touch on the whistleblower protections, as well as how we can, provide some assistance with your compliance programs and policies.
Thank you, Kat, and really appreciate that overview of the DRA 05. And let me connect it up to that New York State legislation I mentioned. And it was chaptered back in October of 21. Why that long ago date matters is because it became actually enforceable about 90 days thereafter. And so we are already in the period where compliance is expected. And if you could go to the next slide, please, Kathy, I'll get more detailed. And we've talked about this a bit before on the webinar. So if any of this is already familiar, let me just quickly provide the overview to reorient you. Jane Sovern, who's a member in our higher education practice, actually wrote a fairly detailed piece on these changes. And so I just wanted to give her credit for some of the material that I'll be summarizing here. But really what the legislation did when it was signed into law was it provided major adjustments to Section 740 of the New York State labor law. And what it did was it dramatically really expanded essentially the reach of whistleblower protections in New York State. And what it does differently now is hail in former employees and individual independent contractors. There are significant expansions of essentially what retaliation looks like, among other changes. You may hear echoes in terms of what Kat was describing in terms of what some of the requirements are for Medicaid providers. And so what we're trying to do by way of this analysis is to bring up to your attention the fact that a crosswalking is really important here. Next slide, please. So in the new standards that Boost 740, essentially there are differences in terms of what had been previously the barriers around where whistleblower protections went and where they did not. And so claims had been limited to those matters that essentially, among other things, provided rather activities that actually violated the law and posed a substantial and specific danger to the public or to public safety, And now, as a point of comparison, there need not be an actual violation of the law, just a reasonable belief that one exists. And essentially, the ways in which retaliation is actually written into the statute is a lot more explicit than it used to be, such that there are greater protections for individuals who seek to bring claims forward. Let me go, Kathy, please, to the next slide. And so what we want to just make sure that, particularly among those Medicaid funded organizations that are taking part here today, and those that do work in the healthcare environment generally, which maybe many more of you, that you're familiar with what essentially this new standard is requiring, and the fact that it may overlay with some of the existing Medicaid responsibilities. There's a need, for instance, to expand policies, to think about the scope of those policies, including whether former employees are hailed in, the nature of notification requirements about the policies, as I mentioned, the lower standards to bring claims forward. So these are the kinds of things that, yes, they exist in different, if you will, silos of our New York State and federal law. But for those providers who operate in the space where they come together, it's really important to think about them as a set of complementary standards. Next slide, please. And so we encourage you to, of course, check with human resource specialists, internally around some of these issues, but also know that we at Bond are here to help. We can certainly bolster your compliance program. We have a lot of deep experience in our health law practice, of which Kat and I are participants, to make sure that you're keeping heed of these whistleblower standards, both the newer ones and those that precede, and making sure that your policies are refreshed where they need to be. So we just encourage you to reach out, whether to either Kat or me, or to the bond attorney with whom you have a trusted working relationship. And we look forward to being of further help as you keep your policies current and ready as they relate to the changing standards in New York State. And with that, Adam, I wanted to turn the floor back to you and thank you for the time that you gave Kat and me this afternoon.
Gabe and Kat, thanks so much. Really appreciate it. Great presentation. Okay, next up, Larry Fennell. Sorry, Larry. Larry is an attorney in our employee benefits group, and he is here to tell us how to make money in cryptocurrency, or at least that's what he told me he was going to do. No, I'm just kidding. Larry is here to talk to us about cryptocurrency, but in the context of retirement plans and what the Department of Labor has said about those. So Larry, thanks so much for being here, even though you're not going to teach us about cryptocurrency and how to make money in that.
Thank you very much, Adam. And I'd be happy to have you sign up for my next webinar, which is done outside of the firm, talking about how to make money in crypto. Just send me over the $500 registration fee. I'd be happy to sign you up. At least that's how I make money in crypto.
Thanks, Larry.
Anyway, Kathy, if you can skip ahead. The Department of Labor in March put out a release addressing the investment of or the availability of cryptocurrency as a planned investment in your 401k plan lineup. Now, in its release, the Department of Labor expressed significant concerns about any offering of cryptocurrency as an investment option in 401k plans, and essentially implied that any such investment would be automatically deemed to be an imprudent investment under ERISA and in violation of a fiduciary's duty of prudence. And in addition to that, they warn that if a plan offers cryptocurrency as an investment, they plan to contact you and question you about why a fiduciary believes it to be a prudent investment and hold you liable for that decision. Overall, while the release focused on cryptocurrency, traditionally like Bitcoin and similar products, it did speak to other types of tokens and other digital assets, and advised that the same reasoning would apply here. But before we go, any further, just first I want to touch on, the duty of prudence. So, Kathy, on the next slide, the under ERISA, plan fiduciaries are required to act solely in the best interests of participants and beneficiaries, and this duty expands to their financial interests under 401k plans. The duty of prudence requires fiduciaries to act with the care, skill, prudence, and diligence under the prevailing circumstances that a prudent person in that capacity and acting and familiar with such matters would use to conduct an enterprise with the same character and with like aims. So as part of that duty, fiduciaries have an ongoing obligation to ensure that only prudent investments are offered. And that requires both initially reviewing an investment to determine if it is in fact a prudent investment and should be made available to plan participants and beneficiaries for investment in the 401k plan, but also requires recurring evaluations of those options to ensure that they remain prudent and should not be removed. There is no bright line test on what constitutes prudence. So as a result, it's a relative matter for plan fiduciaries to consider. Jump into the next slide. Earlier this year, I presented on the Hughes v. Northwestern decision. This Supreme Court decision addressed the prudence of investments, or more specifically, how to deal with imprudent investments. In that case, the plan fiduciaries alleged that while they had a set of underperforming investment funds in the plan, and this is in a nutshell, that the participants could pick and choose what investments they wanted, and as a result, they were not liable for losses from these imprudent fund options. The Supreme Court said no. Every investment option made under a 401k plan must be a prudent one. And in addition to the obligation to ensure that funds are prudent when selected, there's also that obligation to remove imprudent fund options from a plan investment lineup. So it's important that fiduciaries are aware of this and ensure that they do not offer imprudent investments. So, skipping ahead, focusing back on the release here, the DOL implied on the next slide, Kathy, that there is no way that a cryptocurrency investment can be deemed prudent. And it focused on, 5 general categories of concerns. And I'm just going to briefly, touch on these here. But as an initial matter, cryptocurrency, as many of you might be aware, is highly speculative and subject to extreme price volatility. As a result of those swings in value, a plan investment, if offered as a plan investment, it could have a substantial swing downward, can have a potentially devastating impact on retirement accounts, in particular those individuals who might be anticipating retirement in the near future. Secondly, informed decisions. Cryptocurrency attracts a lot of non-expert investors based upon the allure or the hype of making a lot of money, and they don't necessarily come there with an appreciation of the risks. Even expert investors have found it difficult to determine how to value cryptocurrency and how to separate the materiality of material factors that represent value as opposed to hype. As a result, if a participant were to find a cryptocurrency investment, recall that fiduciaries are required to only offer prudent investments. As a result, there might be a false sense of security for participants and beneficiaries if they find the ability to invest in cryptocurrency under their 401k plan lineup. Next up is custodial issues, and unlike plan assets in a 401k plan, which are held in trust or custodial account, crypto is driven by a computer code and generally held in digital wallets. Many times, if you lose your password, forget your password, is not the opportunity to reset it like you can in many other digital formats, but that asset is lost and essentially deemed valueless, zero, and in the event that a password or there were an issue accessing these digital wallets, it could have a devastating impact on the ability on retirement plan accounts. And again, those individuals who are approaching retirement, even a more so significant impact. Similarly, if your account were hacked and someone got into your account and stole those assets, there's no recourse here. There's no ability to, ensure that you're maintaining assets in a trust where it can be protected against that type of recourse. Two additional concerns on the next slide, Kathy. Valuation concerns. Again, going back to what was initially said earlier about valuation, experts have a hard time valuing these assets, making it increasingly difficult to determine the prudency of an investment. And then the regulatory environment. Cryptocurrency markets are new, they're developing, they're evolving, and they have their own rules and regulations. That being said, many investors in cryptocurrency and many people playing in those markets, are able to sidestep that regulatory framework. As a result, you may have unlawful sales of securities that fall outside of security regulations, as well as the cryptocurrency regulations, resulting in unregistered transactions. As a result of certain risks follow from that, where you have inadequate financial disclosures, you don't have financial investor protections under securities laws, as well as the potential that noting the DOL said that cryptocurrency has been found to be involved in illegal activities, and there is potential that those assets may be frozen, at least temporarily, pending any sort of criminal investigation. So now, jump into the final slide here, Kathy. So what does this all mean for planned fiduciaries? And I think there's two key takeaways here. And the first and foremost is that the DOL has implied that this is not a prudent investment, and it's going to audit or investigate, or at least call it what you will, question planned fiduciaries who offer that in their plan lineup. So first and foremost, if you as a planned fiduciary feel that the DOL is wrong and the cryptocurrency is a prudent investment and makes sense in your plan, then you should be prepared for a plan audit. And audits can be long, they can be expensive, and they can use up valuable time and resources at your entity. So be prepared for that. Please also note, this is the first time that I'm aware of the DOL has specifically said a certain class of assets are automatically deemed imprudent. Now, that's something maybe of historical reference here, but this is a release and it's not authoritative. So while it's important to heed this warning, and I wouldn't advise otherwise, there is no statutory authority for the DOL to draw this conclusion. And the ERISA does not permit, by statute, again, the DOL to act in this capacity. So again, not to gloss over that, but DOL is viewing this as an imprudent investment. So if you are a client who wants to offer this as an investment option, please tread carefully and be sure to take this into account. And secondarily, and I think perhaps more importantly, is the DOL does note in one sentence in its release that's going to question fiduciaries who offer a brokerage window in their 401k plan, and through that window, participants have access to cryptocurrency. Now, traditionally, a brokerage window is set up to allow participants to buy and sell a wide range of securities for the retirement plan. So these are for individual participants who are looking for investment opportunity pretty much in the stock market and don't want to rely upon just a specific investment fund lineup that the fiduciaries put together. Historically, the DOL has not investigated brokerage windows, allowing fiduciaries to have some relief from poor investment decisions from participant-directed investments. However, and more or less view the decision to offer a brokerage window in of itself as the fiduciary decision. When you look at the potential vast number of transactions that happen in a brokerage window, it would be unwieldy for any fiduciary to review each and every one to determine whether or not the selected investment or security was a prudent investment. So, I think that, in addition to noting that they're going to look at cryptocurrency as an investment, you have to also think about whether the brokerage window in of itself, particularly in light of the Hughes case in Supreme Court decision, if we are going to be held liable as a plan fiduciary for every investment made under a plan, what does that mean for plans who offer investment, brokerage windows and allow them to have access to pretty much every investment under the sun? The DOL only focused in this release on access to crypto. So it's possible that, if they do question you about your brokerage window, you want to make sure that your brokerage window does not offer cryptocurrency. If you want to ensure that if you do get a call from the DOL, you can make that representation. However, I think that the statement in of itself from the Department of Labor opens up a Pandora's box of questions here regarding what a plan fiduciary needs to do with respect to monitoring investments in their brokerage window, which may reopen the opportunity for plan fiduciaries to consider, the actual decision to offer the brokerage window and whether it remains prudent in light of this release. Again, I think more to come on this. I think it's, I don't want to scare everyone who may have a brokerage window out there, but I think it's food for thought here and something that should be on the minds of plan fiduciaries who have plans that offer brokerage windows, both in the near term, checking on cyber and cryptocurrency from your window, in the long term, the prudency or they'll say this slightly longer term, the prudence of offering that type of brokerage window. But I'm sure that we're going to see more on this as time passes, and we'll be happy to report on that when that time does come. Just one quick point: later this week, I'll be putting out a client alert on this, so please, keep an eye on your inbox if you're interested, and you can get some more information and detail on this topic.
Larry, thank you so much. A ton of incredibly helpful information about retirement plans and the potential use of cryptocurrency in those plans. So thanks again. All right, next up, this is the presentation that I mentioned at the beginning of the webinar. We had a number of comments from you asking about remote work and issues related to remote work. This is something that we have seen blow up during the pandemic, and it really hasn't gone away. So I think it's pretty safe to say that remote work is here to stay in the employment context. Next slide, Kathy. We saw the increase or the beginnings of the remote work boom even before COVID. So since 2005, there's been approximately 173% increase in the number of regular telecommuting employees. There's been a 40% increase in the number of employers offering employees the option to work remotely. Pew has said that pre-COVID, only 20% of employees worked from home or all or most of the time. But in December of 2020, which was really in the heart of the pandemic, 71% of employees reported doing their job from home all or most of the time. That number is staggering when you consider the larger context of how many people are employed in the country. 71% were performing their duties at home. Now, we've seen some drop off as businesses have returned to work in person, but the remote work option has continued to be something that many employers are now offering to employees as a perk. A benefit in a very tight job market that might make the difference between someone staying with you or leaving. Next slide, please. So let's think about some practical issues as they relate to remote work. First of all, if you mandate live attendance at the office, are you going to lose key talent? This is something we've seen over the past 2 years. We've seen news articles refer to it as the Great Resignation, where so many employees across the country were leaving one job for another. Remote work may be that triggering decision maker for some employees. So if you're going to require in-person attendance, are you going to lose employees, and how do you plan for that? Do you sow discord among those who stay together or stay and agree to return? So if you have certain employees who you are requiring to return, are you going to sow discord between those and those who you're letting continue to work remotely? Are you losing productivity or incurring other negative consequences from ongoing remote work? I mean, this is pretty self-explanatory, I should say. What is happening with competitors? This is something that many employers are considering right this very moment. If I'm going to require my employees to come into the workplace and my competitors are going to allow remote work, am I going to lose the best talent? Next slide, please, Kathy. In addition to those practical considerations, there are also legal issues that we have to consider, such as, are you registered to do business where the remote worker is located? Must payroll taxes be withheld differently? Are there additional statutory benefits that must be provided? Are there any different employment law requirements? all four of those things all relate to the scenario where you may have a remote worker who is working in a state that is not the state where you do business. You really have to understand the legal issues associated with that, such as payroll taxes. Now, when I refer to statutory benefits or other or different employment law requirements, think about workers' compensation. New York has its own workers' compensation law that provides very specific circumstances under which employees can qualify for workers' compensation. Well, if you have an employee who's working remotely in Pennsylvania or some other state, you have to familiarize yourself with the laws of those states and whether or not they will apply to your remote workers. The last bullet here on legal issues to consider is what I'm going to spend the majority of my time talking about. And that is, should I have a written policy or agreement in place? Next slide. Spoiler alert, the answer is yes. But let's talk about policy and agreement considerations. First of all, any remote work policy, which we recommend if you are having employees work remotely, you need to have a remote work policy in place, and you need to have each employee who is under a remote work arrangement sign that agreement so that they understand exactly what the terms and limitations of remote work are. So first of all, before you get into your written agreement, you need to figure out who is going to be eligible for remote work. You want to make sure that the criteria you use for determining eligibility are as objective as possible, meaning that you have very clear criteria that would make someone eligible. So for example, does the job consist of portable tasks? So are there specific things that can be done remotely? Can job performance be easily measured by outcomes? Are there certain things that would allow you to measure whether or not someone is being productive in a remote work arrangement? Do you have to, in this particular employee's job, interact daily with others? And if so, is remote interaction going to be something that is effective? Does the employee supervise or train others? This may make it less desirable to offer a position, a remote position, that is, because you need someone who's supervising others to be present in the office. Are you going to have a length of service requirement? Meaning, this is some situation where you say employees who have been with the company for fewer than 6 months cannot work remotely, just as an example. Is there a performance or an attendance requirement, such as you would only allow employees who have been with the company and had a good track record in these specific areas to work remotely? Is it some kind of benefit that you offer based upon performance? I think the key is to make sure that your criteria are objective, because if they are not objective, if you are just making remote work decisions on an ad hoc basis without any real eligibility criteria, you open yourselves up to the unfair treatment based upon protected characteristic argument. So let's say you grant a remote work arrangement to one employee and you don't grant it to another employee. You don't really have any clear reason why. The employee who you did not grant the remote work arrangement to may say, well, you're doing that because I'm a member of a protected class. And if you don't have anything other than just a subjective, well, I did let this one employee do it and I'm not letting you do it, you may open yourself up to a potential claim. Next slide, please. All right, so in addition to determining eligibility, your policy has to address a number of things. So for example, your policy has to state the location where the remote work is going to be performed. So if this is at an employee's home office, you need to state exactly where in the agreement. The policy should articulate the schedule. So if you expect your employees to be in the office from 8:30 to 5, the remote work arrangement or agreement should talk about that same schedule. They're expected to be working from 8:30 to 5. They're expected to be available during the hours of 8:30 to 5, subject to any break time. Timekeeping. The policy needs to address how timekeeping is to be done, where it's to be done, if an employee is going to be working more than 37 and a half hours, and the employee is not an exempt employee, you have to make sure that the policy says, if you are going to be working more than 37 and a half hours, you need to get prior approval, because then if you don't have that and your employee is working more than those hours, the employee is non-exempt and therefore would be entitled to overtime, you may have an overtime issue on your hands. The policy should also address expense reimbursement. How are you going to repay employees, or what are you going to pay employees for in terms of equipment? Caregiving responsibilities. This was a big one during the pandemic when schools shut down. Policies should address the fact that you are expecting your employees to work during the scheduled working hours and not to be primary care providers for minors who are in their home. The policy should also address time off. You don't want your employees, particularly those who are non-exempt, to be working when they are supposed to be scheduled for time off. Again, you don't want to run into these wage and hour issues. Next slide, please. The policy should also address confidentiality, ensuring that although the employee is working in a remote location, that the employee maintain the confidentiality of your private work information. Connectivity, it should address specifications that you are expecting for your employee to have related to connections to the internet, because in any remote work arrangement, that is going to be essential. Safety and health, you'll talk about in the policy what you expect in terms of a safe workspace. You want to make sure that the employee has the appropriate work area to perform the remote work. Although it is not in your physical office, you have to think about that remote workspace as an extension of the physical workspace. Other policy applicability. So you want to make sure that your policy makes it clear that all other workplace policies that you have in place, including those that would be in your employee handbook relating to harassment or discrimination, those policies are going to still be in effect. You want to make that remote workplace, like I said, an extension of your physical workspace. This is an important, these last two bullets are important, and I think they're things that you really need to pay attention to in your policy. You have to say that the remote work arrangement either is going to last for a particular duration, or you want to say that it's going to be periodically reviewed to make sure that it's working out, and that you as the employer have the unilateral right to revoke the remote working arrangement. That is very important. What you don't want to get into is a situation where you have an employee who's working remotely. The remote work relationship clearly is not working. You're seeing a significant drop off in productivity. You want to have that right to review and revoke right in the agreement that the employee has signed. Next slide, please. I'm not going to cover this in detail because I only have about 15 minutes here, but there are a lot of issues in addition to what I talked about earlier with employees who are remotely working out of state. So there are legal tax consequences both for you and for the remote employee. There are other employment law concerns such as comp, which I mentioned earlier, unemployment insurance, state-specific employment laws. You really need to make sure you understand those if you are going to allow remote work, specifically for someone to remotely work in a state where you are not located. Next slide, please. The EEOC has provided some guidance on remote work during the pandemic. A couple of important things to note. I'm not going to read through all of this, but the EEOC has indicated that your temporary shift that virtually every business made during the pandemic to remote work doesn't have to be permanent. It doesn't mean that you have to grant all requests for remote work going forward, just that you did that during the pandemic, and it doesn't have any precedential basis, essentially. Next slide, please. All right, so just a couple of takeaways. Carefully consider requests to work remotely when framed as a request for reasonable accommodation. I didn't really get into this again due to the limited time, but Some employees may request remote work as a reasonable accommodation for a medical condition. You need to carefully consider those requests to work remotely and work through the interactive process with your employees. That may be a good topic for another segment on these webinars, reasonable accommodations in the medical context. You need to engage in fact-specific analysis before denying or taking a job performance while working remotely during the pandemic into consideration. And then finally, what I just mentioned, make sure you're regularly communicating and evaluating with your employees. Okay, so I think that's it. Finally, we're gonna plug this a couple of times. We are putting on an in-person presentation on June 9th at the DoubleTree by Hilton Hotel in Syracuse. I will be doing it along with another of my partners. It's meant to be an intensive program on workplace investigations. We'll work through some hypotheticals, and we're also going to talk about discipline discharge and how to do that appropriately in New York State. So we will have more information about that. We're just teasing it now. Thank you all for being here today. If you have any questions about any of the topics we talked about, you have our contact information. Thank you again, and we look forward to seeing you next Tuesday.